So in England and Wales there are two main pieces of legislation which are important. The first is the Human Rights Act 1998, then the second is the European Convention on Human Rights, ECHR. So the ECHR lists a number of different human rights which people have, providing their state, i.e. their country, are part of the ECHR. And so it's the Human Rights Act 1998 which makes the UK become part of the European Convention. And so it's this legislation which gives the ECHR legal binding on the country. And this is just a matter of international law. In the UK, in England and Wales, the country is not bound by international law unless we make a domestic statute, a statute made in our Houses of Parliament, to give the international law essentially permission to have authority over our domestic law. So Section 1 gives action to the Convention rights. It gives legal binding to the Convention rights. So these are the rights which we as citizens in England and Wales can rely on. And so these are Articles 2 to 12 and 14 of the Convention. Any other articles which are not within those within that section cannot be relied on by individuals in England and Wales. Then Section 3 concerns the interpretation of legislation, and this is really important. Subsection 1 of this section provides that, so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. Subsection 2 goes on to mention that this section applies to primary legislation and subordinate legislation whenever enacted, does not affect the validity, continuing operation or enforcement of any incompatible primary legislation, and does not affect the validity, continuing operation or enforcement of any incompatible subordinate legislation. If disregarding the possibility of revocation, primary legislation prevents removal of the incompatibility. And so what this essentially means is that when you go to court, and if you're going to be sentenced or charged based on a certain part of statute, then the court must interpret that statute, giving effect to the Human Rights Act and the rights within the ECHR as far as they're able to. So as far as the courts are able to, they must interpret the legislation with regards to the Human Rights Act. However, if they're a part of the legislation which is clearly not compatible with the human rights, it breaches any of the human rights, and the court cannot interpret the legislation in a way which is compatible with the rights, then the court cannot not apply that legislation. They must apply the legislation as it is, and they must sentence an individual based on that legislation. What would happen then is the courts would have to issue a statement of incompatibility to the government, asking them to make it compatible to the ECHR. But that's not a legal requirement. The government do not have to make it compatible with the ECHR. And so, let's say some of the legislation was not compatible with the ECHR, and the government would not change it. You could then go to the European Court of Human Rights to argue that. And whilst I'm on this topic of the Human Rights Act and the European Convention on Human Rights, you'll notice that I've written the Council of Europe. That's because the ECHR is completely separate from the EU, which the UK has now left. The EU is governed by the Council of the European Union, and that's completely separate. The Council of Europe is completely separate to the EU, and they are in charge of the European Convention on Human Rights. And when you go to the European Court of Human Rights, it is the Council of Europe who are in charge of that. And the Council of Europe have nothing to do with the EU. And so we are still currently under the ECHR, although the previous Conservative government did make it clear that they weren't a fan of the Human Rights Act 1998 and the ECHR, and they were going to bring in a Bill of Rights, but that's a topic for another lecture altogether. And finally, on this slide, Section 6 provides acts of public authorities. And so that means it is unlawful for public authority to act in a way which is incompatible with a convention right. And this basically means that you can only enforce the ECHR against public authorities. So that's the government, the courts, Home Secretary, Home Department, anyone who has a public capacity. You cannot enforce ECHR against private individuals or private businesses. But anyway, now that we've had a discussion of that, let's go into the areas of the ECHR, the various articles which are particularly relevant for this. Okay, so now let's go into the actual articles relevant to this lecture. So, the first article of the ECHR, which is relevant for us today, is Article 9, and that's the freedom of thought, conscience and religion. And this provides that everyone has the right to freedom of thought, conscience and religion, and this right includes freedom to change his religion or belief, and freedom, either alone or in community with others, and in public or private, to manifest his religion or belief in worship, teaching, practice and observance. So this means you're allowed to have a religion, and you've got the freedom to practice that religion however you may wish. And the freedom to manifest one's religion or beliefs shall be subject only to such limitations as are prescribed by law and are necessary in a democratic society in the interests of public safety, for the protection of public order, health or morals, or for the protection of the rights and freedoms of others. And so essentially, although you can practice your religion in any way you like, the state are allowed to put in limitations if it's necessary for a democratic society or for the safety of the public or health and morals. And so there are some limitations to this, but essentially one is allowed to have an opinion about different topics, even if they are controversial topics or there are organisations which were involved in the topic which have been banned. These organisations are often banned due to their actions. So if you were expressing your opinions or thoughts about a matter such as a war, this would not be a crime, and if prosecuted, there would be grounds to sue the state in the European Court of Human Rights. And so relating this back to the Palestine action and Palestine protests, you're allowed to campaign and protest about Palestine, but Palestine action has obviously been prescribed because it's been felt that there's public safety risks and it may not protect the rights and freedoms of others potentially. So that's the key law for this bit. And moving on, we have Article 10 of the ECHR, and this is about freedom of expression. It provides that everyone has the right to freedom of expression, and this right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. This article shall not prevent states from requiring the licensing or broadcasting television or cinema enterprises. So this means that everyone has a right to freedom of expression, and you are allowed to express your opinions in whatever way you like. But then if you are a business or journalist, broadcasting organisation, whatnot, the state are still allowed to license you, i.e. you're required to be given a permission from the state, which you often need to pay for in order to have that freedom of expression. It goes on to say that the exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions or penalties as are prescribed by law and are necessary in a democratic society in the interests of national security, territorial integrity or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. So this right has similar limitations as the previous one, but it's also worth mentioning that although you do have the freedom of expression, with that right you do have duties and responsibilities as well. And so there can be restrictions in place if freedom of expression has a risk of interfering with a democratic society, security, or public safety, and so on. So with your opinions and thoughts, you are indeed allowed to share and publish these in either public or private manner, so long as they do not negatively impact any other individual or group or organisation, and it must also not be criminal behaviour. Helping those in need or sharing an opinion online is not a crime, and if convicted there would again be grounds to go to the European Court of Human Rights. So moving on again, Article 11 of the ECHR is the freedom of assembly and association, and this provides that everyone has the right to freedom of peaceful assembly and to freedom of association with others, including the right to form and to join trade unions for the protection of his interests. No restrictions shall be placed on the exercise of these rights other than such as are prescribed by law and are necessary in a democratic society in the interests of national security or public safety, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. This article shall not prevent the imposition of lawful restrictions on the exercise of these rights by members of the armed forces, of the police, or of the administration of the state. So essentially, you have the right to protest and to form peaceful assemblies and to associate with others, unless there are problems with national security or public safety and so on. And so, before Palestine Action would have been prescribed, you would have had the right to associate with them. But since they've been prescribed, this would have been due to issues of national security or public safety. You no longer have that right. But essentially, protests are legal, as we have seen, so long as they are peaceful and do not lead to any criminal behaviour or behaviour which could risk the health and safety of the public. And that's something we've seen in the previous part of this lecture, which looked in detail at the relevant human rights legislation. Which looked at the relevant legislation around protests, particularly the Public Order Act of 1986. Then finally we have Article 14 of the ECHR, and this provides that there is a prohibition of discrimination. So the enjoyment of the rights and freedoms set forth in this convention shall be secured without discrimination on any grounds such as sex, race, colour, language, religion, political or other opinion, national or social origin, association with a national minority, property, birth or other status. So regardless of your religion, political or other opinions, or whether you're a minority, if you are campaigning against an issue, such as the Palestine issue, you cannot be discriminated against that. So let's say, to use an example I was given, if you were Muslim and you were discriminated against and arrested or imprisoned for whatever reason because you were protesting for Palestine, yet your white counterparts, English counterparts, were not interfered with by the police, that's a clear case of discrimination, and that's clearly not allowed. Public authorities such as the state, government, courts and judges cannot discriminate based on these grounds at all. Therefore, if one was sharing an opinion and actively advocating for a specific situation such as war, such an individual could not be prosecuted because of these protected characteristics, and they would indeed be grounds to go to the European Convention on Human Rights. That would be something I would highly recommend as well. Obviously, see a legal advisor, barrister or solicitor for that, but it's important that we have these human rights available for us, I would say. And going on a bit further into this law around discrimination, we have the Equality Act 2010. And this is essentially domestic law in England and Wales, and Section 4 provides the following protected characteristics. That's age, disability, gender reassignment, marriage and civil partnership, race, religion or belief, sex and sexual orientation. And so no one in the UK, in England and Wales, can discriminate anyone else based on these protected characteristics. And if you were discriminated based on any of these characteristics, that is a crime, and the other person can be liable. And so similarly, if you're doing protests or whatnot, you cannot be discriminated even by public authorities on this legislation, but with public authorities, and so one has been protected under this statute, you obviously also have the European Convention on Human Rights you can rely on as well.